Good morning. We will call this committee meeting of the Judiciary Committee for today, Tuesday, May 20th, to order, and we will go into recess. We'll hope to be back shortly. We don't have a lot of time this morning. Good morning, everybody.
All right. While everyone is getting settled in, I'd like to reconvene the Judiciary Committee meeting for Tuesday, May 20th, 2025. We have two referrals from the House on our agenda. I'd like to start with number one, which is I'd actually like to start with number two, which is substitute for House Bill number 7275, an act concerning the regulation of cigarettes, tobacco products, electronic nicotine delivery systems, and vapor products. The motion will be a JF. A motion from Senator Winfield, a second from Representative Fazzino. This is a bill that comes to us from the Finance Committee, and it makes various changes to the laws on cigarettes and tobacco. I believe the reason it is here is twofold. First, there is an extension of an existing criminal provision in lines 89 through 91, which makes it a violation of the provisions of subsections A, B, and C, guilty of a C misdemeanor, or sorry, an A misdemeanor for a first offense and a C felony for a second offense. There's an expansion in the preceding parts of that section, so that is an extended criminality, not a new penalty. The other reason I think it is here is there are two separate CUTPA violations envisioned in this bill. Those would be on lines 104 through 108, as well as 189 through 193. Let me say at the outset, I have discussed this bill with Chairwoman Horn. My understanding is there are amendments to this bill that are contemplated before this bill runs on the floor. I've expressed my concerns with the cut provisions in this bill as written. I think this is yet another example of here we go again in this legislature of when we don't know what to do with something, let's just make it a CUTPA violation and hope that solves the problem. But there's a problem with that in this bill, and that is that this bill already has a $10,000 fine imposed for the violations. And under CUTPA, there needs to be what's called an ascertainable loss, which means there needs to be someone who is harmed or damaged. And here, what we're talking about is packaging of nicotine. And so if somebody doesn't do what's contemplated, there's really not a physical person who's harmed by the lack of packaging. So there isn't an ascertainable loss, and frankly, really can't be a CUTPA violation, even if there was an unfair trade practice. So I believe the fine is sufficient. The new $10,000 fine that's envisioned here, which I guess would also be our cognizance as well. And so given where we are in the legislative process, I'm not going to ask that we strike the cut provisions at this point, but I have discussed it with Chairwoman Horn, and my understanding is the cut provisions will be stricken on the House floor. So I will support the bill today to get it out of committee, but do expect those provisions to fall out of the bill. Senator Kissel.
Thank you very much, Chairman Staffstrom, and I very much appreciate that articulation of the basis of as why this bill's here. On the fine, which I believe you said was 10,000, which is a lot of money. I'm just wondering, is that just a flat fine or is it up to 10,000? And if it's a range, what would be the determinant factors and for a judge to ascertain what's the proper number?
To you, Senator, I believe the fine I was referring to is on line 185 of the bill. It says it's up to $10,000, and the fine is imposed by the Commissioner of Revenue Services. The bill does not articulate what factors the Commissioner will consider. To you.
Thank you. I appreciate that clarification. So the Commissioner of Revenue Services, currently Commissioner Boughton, could say $1 or $10,000, and we don't really know what, if I was an attorney representing someone charged with this, and we had some sort of administrative hearing or review, I don't know what kind of pitch I would make to have a small penalty as opposed to a large. Uh, was there no guidance at all regarding that?
I don't see anything in the bill. I guess generally speaking, in these types of instances, what the administrative agency considers is certainly, if it's a first time violation or an unintentional violation or um, uh, maybe an administrative snafu, et cetera, where there wasn't sort of an intent to violate the provisions of the statute, the commissioner could impose a smaller fine than a more punitive one through.
Thank you very much, Chairman Staffstrom. So it's sort of a mens rea malice, or not malice, but a mental determination to avoid the law as opposed to just negligence. And one other question, and it's probably, or it's clearly outside of our area of cognizance, but I just had a question and I want to credit Representative Veach, which raising this issue. Do we know what homogenized tobacco is?
I do not.
Thank you, Mr. Chair. Thank you.
Further questions or comments on this bill? Are there further questions or comments? Representative Dubitsky, followed by Representative Tigliano.
Thank you, Mr. Chair. I'm looking at lines 132 and on, and there seems to be there's 3 provisions, B, C, and D, which are incorporated into the fines. The violation of one of these 3 or all of these 3 result in fines. The first one being selling, you basically can't sell these things. And then there's delivery and transportation of these electronic nicotine delivery systems or vapor products. But the fines in where is it? In sections F and G, which is lines 181 through 183 and 184 through 188, talk about in the second one in G, it talks about a fine of not more than $10,000 for each violation. And I don't see anywhere where it tells you what a violation is. So is it that one shipment of these things is a violation? There's a separate violation for each package, each violation for each cigarette? How do we determine there's a $10,000 violation in lines 184 through 188, and there's a Class B misdemeanor in 181 through 183? What constitutes a violation? Do we know through you, Mr. Chair?
So I think it depends on the context, but so let's take C, which I was just looking at, for example. It says no common carrier or contract carrier shall knowingly transport. So common carrier, I assume, refers to, FedEx or UPS, et cetera. And so, or a trucking service. And it says they shall not knowingly transport a certain product. My assumption would be, based on the context of how that's written, is sort of one truckload. So whatever's on the truck would constitute the violation in that context to you.
The whole truckload, okay,
Or,
so,
or whatever's on the truck. So it might not be an entire truckload full of product, but if it's a box on the truck that the common carrier knows to be on that, then yeah, that would constitute the violation.
okay, so if a driver, for example, or a common carrier was carrying like one pallet full of these things, that would be a violation. If he was carrying two pallets at the same time, would that still be the same violation, or would that be a second violation?
I believe if it's all in the same truck, it's one violation.
Okay, how about if those two pallets were going to two different places?
Again, I think the fact that they're on the same truckload is probably just one violation.
Okay, is there a line that you can point me to that would indicate as much?
Again, I'm just reading it based on the context of the paragraph as a whole, but that would be my understanding based on the paragraph as a whole.
Okay. I'm a little worried about that because those three paragraphs appear to touch on different types of people. So one is with regard to selling, one is with regard to transporting. And the other one seems to be with regard to shipping. So each of these individuals who's targeted by each of these paragraphs may interpret this differently. And I'm concerned, especially with the inclusion of this CUTPA violation, in addition to a $10,000 civil penalty, in addition to a Class B misdemeanor. So that for a first offense and a Class A misdemeanor for a second offense. So I'm very concerned that these penalties are premised on violations that are hard for these people to discern. And I appreciate the chairman's interpretation of this as being, a truckload is a violation, but I don't see it in here where that's defined. So for the purposes of today, I think, especially based on the chairman's comments about the CUTPA violation, I'm going to propose an amendment to this to remove the CUTPA violations. So I make an oral amendment. I propose an oral amendment to strike lines 104 through 108 and lines 189 to 193. And I ask for a roll call vote, please.
All right, so there's a motion made by Representative Dubitzky to strike lines 104 through 108 and 189 through 193. I believe it was seconded by Representative Retigliano. As I said at the outset, I agree with the intent of this amendment. I agree that this language should be removed when this bill ultimately hits the floor. I'm going to ask my colleagues to oppose it today because unfortunately we seem to have this wacky rule around here that something needs to get a new file, and if we amend it and I have no idea why, but it will presumably slow the bill down as opposed to it just coming out for the way it is. So because of procedural reasons, I'm going to ask my colleagues to oppose this today. Madam Administrator, please. Oh, hold on. Discussion on the amendment. Representative Retigliano.
Oh, thank you, Mr. Chair. Through you, Mr. Chair, I just wanted to ask, when I was reading lines 104 through 108, it says that the Commissioner of the Consumer Protection would ask the Commissioner of Revenue Service to bring action. Is a CUPTA violation, is that something that would be from the Attorney General? Or is that one of the departments or the commissioners can do that themselves? Through you, sir.
So most CUPPA claims in the state are actually brought by private lawyers on behalf of private litigants. That is the vast majority of CUPPA filings in our state courts. The Attorney General's office under many statutes does have an ability to bring a CUPPA violation. The Department of Consumer Protection does as well. I'm not saying it doesn't happen elsewhere, but I can't personally recall seeing language in our statutes elsewhere where someone other than the Department of Consumer Protection or the Attorney General are authorized to bring a CUPPA action.
Thank you. Through you, sir. Either to you or the proponent of the amendment, either way. So can the Department of Revenue Service actually bring suit? Or I was unclear. I understand what you just said, and that makes total sense. I do know the Department of Consumer Protection can do it, the Attorney General. I'm not sure if the state's attorney can get involved with that also. I just wasn't aware that the Department of Revenue Services could do it and why they would need the Department of Consumer Protection to direct them. Through you.
So on the first part of your question, no, the state's attorney cannot do it. They do not have civil authority within the state. I assume the way this would work is the Department of Consumer Protection would authorize the Commissioner of Revenue Services to bring the action in the name of the Commissioner of Revenue Services, but it would actually be the Attorney General's office who is acting as the lawyer for the Commissioner of Revenue Services in that instance in bringing the action, would be my assumption based on this reading. Again, this is a referred bill that came to us and admittedly confusing language, but that would be the way I would interpret it.
So through, sir, so would they use their own attorneys or their own legal staff within the department, or would they have to go either hire outside representation or use the state's attorney or the Attorney General? Is this sort of like an internal function of theirs, or do they have to go out of their department?
I believe under our state laws and perhaps even our Constitution, the Attorney General is allowed to assign or select counsel. So it could be somebody in their own office, or under certain circumstances, they could hire outside counsel.
Oh, thank you, sir. I appreciate your answers and enlightening me. Thank you.
Any other questions on the amendment? Any other questions on the amendment? If not, Madam Administrator, please call the roll.
Roll call vote on Amendment A. Winfield,
One bill and a negative.
Sasser,
No.
Flexer,
No.
Gadkar Wilcox,
No.
Pazino, Kissel, Fishbein, Blumenthal, Brown,
Brown votes no.
Cabrera, Callahan,
Yes.
Chicarella,
Yes.
DiCaprio,
DiCaprio, yes.
Delaney,
Delaney, no.
Dillon,
Dylan, no.
Doucette, Dubitsky,
Yes.
Elliott,
Elliot, no.
Gaston,
No.
Gilchrist, Godfrey, Howard,
Yes.
Jacobson, Johnson,
No.
Khan,
No.
Mark Muir,
No.
Lesser,
No.
Mar,
No.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, no.
Havelock Tomato,
Havelock Tomato votes yes.
Perillo, Quinn, Raman, Roberts,
No.
Retigliano, Sims, Beach,
Beach votes yes.
Walker, Wilson,
Wilson votes no.
and Mark. Final tally on the roll call vote on Amendment A is 11 voting yea, 21 voting nay, and 9 absent.
Amendment fails. Further discussion on the bill. Further discussion on the bill. Representative Tigliano.
Thank you, Mr. Chair. Mr. Chair, I was confused by in the bill, and we had it in finance also. We were confused by the inclusion of cigar or the words premium cigar. So I wasn't sure if you had an explanation of what defines something as a premium cigar. Is it a price point, or is there certain attributes of a cigar that make it a premium as opposed to just a regular old cigar?
If I recall correctly, there's a definition in the bill. I believe it's lines 54 to 58.
I appreciate that. So I read it. It sort of seemed to be a description of a cigar. My question was, what makes it a premium, and how does one know that they're buying a premium cigar so they're not subject to the rule of the bill? Because there's penalties for not following direction of the bill, which I think would make it sort of cognizant of the committee. If you don't follow the rules and you just buy what this bill is suggesting as a regular old cigar as opposed to a premium, then you are subject to the fines or the penalties within the bill.
Yeah, I see a differentiator, but I believe it says wholesale price of not less than $30 per cigar.
Wholesale price, no. Right. So I see what you're saying. You're saying on line 57 and 58, it's saying it's what defines a premium cigar is the price. It's $30, not less than $30 a cigar. So everything up to $30 is a regular cigar, and anything over $30 is a premium cigar and not subject to the provisions of the bill.
As best I understand this, that's correct.
So, Mr. Chair, I know we don't like to amend the bill in committee because it slows down the bill, but we tried to do this in finance. And in finance, we literally had a simple little where we removed the word premium, and it all of a sudden, cigars were able to be bought and sold as they are today. Most people buy them through the mail. There's a lot of Connecticut companies that actually deliver them through the mail. So even I don't have a formal amendment, sir, but I would like to just strike the word premium from the word cigar, and then anybody who enjoys a cigar, which I'm not a big cigar smoker, but I know there's quite a few people out there who do enjoy cigars and who buy them from all over the place. And some might think a $6 cigar is a premium cigar, my understanding. And I would like to remove the word premium from line 54 before the word cigar. And I would like that to be a formal motion for an amendment, sir. Thank you.
Is there a second? All right, so we have a motion to strike the word premium in line 54. Motion was from Representative Tigliano. The second is from Senator Ciccarella. For the same reasons as before, I'll ask my colleagues to oppose the amendment. Further
Pardon the interruption, sir. When we do take a vote, I'd like to be taken by roll.
Yep, it will be a roll call vote. Yes, Senator Ciccarella on the amendment.
Thank you. And I also support this amendment. We also had a similar bill in general law, and we were trying to figure out what the purpose was. And we do see that there are young children that have access or get tobacco products or vape products, and we want to address that. And when we were having discussions with stakeholders and the committee, it seems to be obvious. They get these from bodegas, or maybe we heard some other situations where maybe an older brother who does have an ID will go and get them and then give them to the younger brother, and he, sells them or distributes them. And when we were talking about the cigar part of this, and that's why I'm going to speak to this, the minors that we're trying to focus on really aren't smoking cigars, premium or otherwise. And in this section, it talks about mass production and being used, a machine or mass production being used, not a hand rolled cigar. You could get a $10, $12 hand rolled cigar that someone makes, and it's not over $30, and they're more affordable than obviously a $30 cigar. That's quite expensive. And when having that discussion, a lot of individuals purchase their cigars online, JR Cigars and many other websites, because they're a little bit more affordable. Kind of takes the middleman or a local tobacco shop out of it. And I see this as a really a common sense amendment, as it's not falling into the hands of minors, right? These cigars are a little bit more expensive, $8, $10, $12, $15 cigar. We see the kids sometimes using the cigars, or maybe these factory made or machine made cigars, to use the wrapper for smoking other substances. But this right here would address the problem that we heard in general law, that some of the individuals who try to save money will buy them online, and they buy cigars that are $10, $15, $20, $30. And I believe that the amendment before us is common sense. I know the good proponent of this amendment is also on general law, and I just had a quick question for him. By taking the word premium out, would that address, I guess, the concern of trying to keep the tobacco products out of the minors' hands, but also be able to provide that outlet or place to purchase these cigars for the individuals that are clearly of age, can enjoy them, and can purchase them maybe at a reduced cost through you, Mr. Chair?
Yes, to you, Representative Tigliano.
Thank you, Mr. Chair. I guess the intent of this bill is a good one. We're trying to keep nicotine and cigarettes and tobacco products out of the hands of minors. But cigars, on the other hand, really, I don't believe it's something that a 17-year-old or a 14-year-old is looking for. I don't think they're looking to buy a Baccarat through the mail and have it delivered to the house. If they do want something that they could use to roll illicit substances like marijuana, that would be one of those cigars you'd buy at a local grocery store or convenience store. The idea is that although we may want to restrict all the electronic nicotine delivery systems and all the other things in the bill, cigars really just don't seem to fit that narrative. The penalties in this bill are stiff for somebody who violates it knowingly or unknowingly. The fines are upwards of $10,000. And then we were doing some further reading, and not only would that business be subject to the large fine, they'd also be subject to the storage fees for the confiscated product that was being held by the either DRS or DCP. So we're hoping that the word premium, it allows cigars to continue to be sold at the way they are currently, and then everything else would be subject to the legislation. Thank you, Mr. Chair.
Further on the bill, Representative Callahan, followed by Representative Dubitsky.
Thank you, Mr. Chair. And just to kind of adding on to what Representative Rutigliano just mentioned, if you have a high fine, which is a very high fine, even compared to some of the legislation we did yesterday, then there could be storage costs. Do you know if there's a limit to the stuff could be destroyed in a day, it could be destroyed in a week, it could be destroyed in a month. So these, not only is it a high fine, but it could rack up storage costs for weeks and months at a time. Do you know if there's a limitation on that, or if the state's going to be liable to destroying it or doing something with it within a predetermined amount of time, Mr. Chair?
I do not.
So it has the potential of actually adding up to a massive fine, and I'm just thinking of that in line with some of the other penalties we have for actual drugs, psychedelics, things like that. It doesn't seem like it's in line, and that could be a problem if the state falls behind and confiscates a lot of this product. You could have several trucks that sit in storage, and I think fining people for malfeasance is fine, but is okay, I shouldn't stop using the word fine, but if it ends up being accumulated cost because the state can't handle the loads that they've confiscated and they can't destroy them in an amount of time, I think that could be an unintended consequence of the bill. So I just have a problem with this section and in the amount of money it could lump onto a particular company. So I appreciate the opportunity to speak.
Representative Drubitsky?
Thank you, Mr. Chair. I just have a quick question for the proponent of the amendment, if I may.
Please proceed.
Thank you. The amendment was to remove the word premium from line 54. And 54 essentially is the definition of premium cigar, and that would leave just the word cigar. And I am doing like a quick word search, and I find that the word premium is also used in line 49. And if the word premium is removed from 54, should it not also be removed from line 49? And would the good proponent consider amending his motion to also include the removal of the word premium in line 49?
Representative
Through you.
Retigliano?
It's a very good point brought up by the good representative. I'd be happy to withdraw my amendment because I don't think I can amend an amendment. And then we could consider making a new amendment. I even invite the good representative to make a better amendment than I did myself through you. With that, sir, I would like to make a motion to withdraw my amendment.
All right, and I believe it was seconded by Senator Chigarella. Is he here?
One second, sir, we'll grab.
Senator Chigarella, will you withdraw your second?
Draw.
Okay, so the amendment is withdrawn. We're back on the bill, and I will turn to Representative Drubitsky on the bill.
Thank you, Mr. Chair. Based on the previous colloquy, I would make a oral amendment to strike the word premium from line 54 and line 49.
Is there a second? All right, so we've got a motion to strike the word premium in line 54 and the word premium in 49 and 54. Motion from Representative Drubitsky, seconded, I believe, by Representative Retigliano. Discussion on the amendment. Senator Kissel?
Yeah, just a quick question either to you, Chairman Staffstrom, or to the proponent of the amendment. By getting rid of the word premium, what does that do to the definitional section where it says $30 or more? Does it sort of just make it neutralized, or does it just hang out there and have no bearing? I just don't know the interreaction of those two terms.
Representative Drubitsky?
Well, if I may defer my answer to the proponent of the previous amendment, perhaps he has a better handle on the answer to that. If I may, Mr. Chair.
Representative Retigliano, do you accept the yield?
I certainly do. I would ask the questioner to just repeat it really quick because I was distracted by my colleague sitting next to me.
Senator Kissel?
Thank you very much, Chairman Staffstrom. To Representative Retigliano, the good House ranking member on the General Law Committee. There's sort of two sections in here. We have the notion of premium cigar, but then Chairman Staffstrom indicated that premium is then subdefined as a $30 cigar or more. And this amendment just gets rid of the terminology premium cigar. So it still leaves that area that says $30 or more. And is that just superfluous language now, or with no meaning, or does it have any kind of import at all? Through you, Mr. Chair.
Committee will stand at ease for a moment.
Did we think $30 more?
Mr. Chairman, he asked me, I defer to you.
So basically, wait, I'm telling you, wait, listen. So
All right, we are gonna come back to order. Representative Dubitzky, you have the floor.
Thank you, Mr. Chairman. I withdraw my amendment.
Okay, so withdrawn and withdraw the second. The amendment is withdrawn. I think that was Amendment C. I'm now going to recognize the ranking member, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion that we strike section 2 from the bill that's before us, which is HP 7275.
Second.
Motion to strike Section 2 from Representative Fishbein, seconded by Senator Kissel. Madam Administrator, please call the roll.
A roll call vote on Amendment D. Winfield,
Yes.
Staffstrom.
Yes.
Flexer,
No.
Gadkar Wilcox, Fazino, Kissel, Fishbein, Blumenthal, Brown,
Brown votes yes.
Cabrera, Callahan,
Yes.
Chicarella, DiCaprio,
Caprio, yes.
Delaney,
Delaney, yes.
Dillon, Doucette, Dubitzky,
Yes.
Elliott,
Yes.
Gaston,
Yes.
Gilchrist, Godfrey, Howard,
Howard, yes.
Jacobson, Johnson,
Rip Johnson votes yes.
Khan,
Khan, no.
Lamarck Muir, Lesser, Mar,
Mar votes yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Pavlock D'Amato,
Pavlock D'Amato votes yes.
Perillo, Quinn, Rahman, Roberts,
Roberts, no.
Retigliano, Sims,
Sims, no.
thank you, Beach,
Beach votes yes.
Walker,
Walker votes yes.
Wilson,
Madam Clerk?
yes,
Who must-
Representative.
Dylan
Patrick Cho?
votes yes.
Thank you.
Madam Clerk,
Yes,
Lamarck Mia votes yes.
thank you.
Madam Administrator,
Representative Doucette?
Doucette votes yes.
Thank you.
Administrator, when you're ready on the amendment, please.
Thirty-one voting yea, 4 voting nay, and 6 absent.
The amendment is adopted. Section 2 is stricken. Further on the bill is amended. Further on the bill, if not, Madam Administrator, please call the rule. Madam Representative Perillo?
Thank you, Mr. Chairman. I appreciate it. So just for my clarification, I mean, section 2 is a pretty substantial portion of this bill. So now that 2 is out, if you wouldn't mind, just kind of briefly, for my own benefit, walking me through what is remaining in this bill that we're doing?
The sections other than section 2.
No, I appreciate that, Mr. Chairman, but could I get a little bit of detail?
What is left in the bill is sections 1, 3, and 4, which section 1 deals with the expanded definition of cigarette. Section 3 involves improperly transporting e-cigarettes, and section 4 is a civil penalty.
Thank you.
Further on the bill, if not, Madam Administrator, please call the roll.
Roll call vote on 7275 JFS to the floor with Amendment D. Winfield,
Winfield in the affirmative.
Staffstrom?
Yes.
Lexer?
Yes.
Gadkar Wilcox? Pazino? Kissel? Fishbein? Blumenthal? Brown?
Brown votes yes.
Cabrera? Callahan?
Yes.
Chicarella?
Yes.
DiCaprio?
DiCaprio, yes.
Delaney?
Delaney, yes.
Dillon? Doucette?
Doucette, yes.
Thank you.
I
Dubitsky?
apologize.
It's okay. Dubitsky?
Yes.
Elliott?
Yes.
Gaston?
Yes.
Gilchrist? Godfrey? Howard?
Howard, yes.
Jacobson? Johnson?
Rep. Johnson votes yes.
Khan? Lamarck Muir?
Yes.
Lesser? Mar?
Mar votes yes.
Miller? O'Day?
O'Day, yes.
Osborne? Pavlik
Yes.
Tomato? Thank you.
Whoops, that's Osborne. Osborne votes yes.
Thank you. Pavlik Tomato?
Pavlik Tomato votes yes.
Perillo? Quinn? Rahman? Roberts?
Yes.
Retigliano? Sims?
Sims in the affirmative.
Veach? Veach votes yes. Walker?
Walker votes yes.
Thank you. Wilson?
All right, turning to item number 1 on our agenda, substitute for House Bill number 7196, an act concerning limitations on the use of non-compete agreements. I'll entertain a motion in JF. Motion from Representative Wilson, seconded from Senator Winfield. Is there discussion on the bill? Representative Fishbein first.
Thank you, Mr. Chairman. Initially, Mr. Chairman, why is this bill before us?
I believe this bill, the bill comes to us from the Labor Committee, and I believe the reason it's before us is it involves actions by the Attorney General. There are limitations on what the courts can find. There are civil actions as well as civil penalties in the bill. Frankly, I believe much of this bill is our cognizance. To you.
Thank you, Mr. Chair. Looking specifically at lines 87 through 90, it talks about covenants that are void and unenforceable, and I'm looking at the clause geographic areas in which a worker neither provided services nor had material presence or influence during the 2 years prior to such separation from employment. And I'm trying to figure out how that works into the rest of the public policy, if you know.
I believe the intent of this is to prohibit non-competes in a geographical area outside of where the worker was providing service to you.
Okay. I'll try and work with that. Looking at lines 98 through 105, it's a lengthy paragraph, and I was trying to link up where that appears just to be dropped into section 2. And it isn't a preclusion provision, but when I look at the first line, a covenant not to compete restricts such workers' competitive activities, so on and so forth. And I'm trying to link that up with, it's not a descriptor, right? Usually you'd have a sentence before that says, you know, these are the things that we're looking to preclude. If you could please point me, where does that capital A link up to?
I think if you look above in line 97, it talks about the following conditions being met, and then there's a list of A through I, which I read to be an inclusive list, and so A would be the first of that list of several items that need to be established in order for a non-compete to be enforceable under this bill through to you.
Thank you. Looking at D of that list, and specifically Roman I, am I to read this that this is supposed to be a portion of the non-compete agreement indicating to the worker expressly that not all covenants to compete are enforceable against the worker? Am I reading that correctly?
Yeah, so I believe D is a notice provision, and so that notice provision in the non-compete needs to lay out each of these items, including essentially notifying the worker that not all non-competes are enforceable.
Oh, thank you for that. In lines 145 through 147, it says the covenant not to compete does not unreasonably interfere with the public interest or is consistent with the provisions of this section, other laws of this state, and public policy. How is an employer to know that, whether or not it's violative of laws of the state or public policy?
That is a really good question, Representative Fishman. I do not have an answer for that.
Looking at lines 223 through 225, it expressly says nothing in this section shall permit the Attorney General to bring an action that would otherwise be barred under the applicable statute of limitations. What is the applicable statute of limitations for this action?
I guess in certain circumstances, without having kind of gone through all the scenarios, I suppose there could be a 6-year contract statute of limitations. You know, potentially a tort statute of limitations of 2 or 3 years. But off the top of my head, I'm not entirely sure of all scenarios.
Yeah, thank you for that. Because, you know, my thought process was, I don't know that it would be contract, because actually what you're looking to do, it's not a breach of contract. You're looking to invalidate or find void the contract.
Representative Fishman, let me interrupt you. My understanding is that the Senate has just gavelled in and gone into recess, so we must conclude our committee meeting at this time. So we're adjourned.
Thank you.